Good morning, ladies and gentlemen. I want to welcome you back. It's January 26th. This is our regularly scheduled Board of Equalization meeting for 10 a.m. It is 10:01, and we are ready to convene the board meeting. Ms. Taylor, could you please call the roll?
Certainly. Chair Cohen.
Present.
Vice Chair Schaefer. Vice Chair Schaefer.
My staff has taken away the muting of my microphone. I've unmuted it now. I'm present.
Thank you. Member Gaines.
The inability to say present.
Oh.
I don't like you having charge of my...
Are they waiting for you now?
Okay.
Vice Chair Schaefer, if we could have you mute your mic, please.
Thank you. Member Gaines.
Present.
Thank
I
you.
said present earlier. I don't know if you're...
I don't know. I didn't hear it. Member Vasquez.
Present.
Deputy Controller Stowers.
Present. Madam Chair, back to you.
Oh, okay. I didn't know Ms. Taylor was going to kick it back. Okay. Yes. All right. So I just wanted to see if there are any opening remarks. Ms. Taylor, if you could call the first item, and then we will move into the first order of business since a quorum is present. And I just as a reminder to everyone that all members and invited guests are simultaneously on a shared open teleconference platform. So we ask for your patience. Those that are calling in on the call line, we need to keep the audio clean and we need to keep it clear. So we are asking that you speak after each presentation once it has concluded, so that the transcriptionist can clearly hear and properly record the meeting. Colleagues, I just wanted to check in to see if you had any comments before we take up our first order of business. None? Okay, thank you so much. Ms. Taylor, please call the first item.
Our first order of business.
Can I interrupt just a moment?
Yes, you may.
I'm sorry, but I just wanted to recognize, now it's not today, but it is in a couple days, I think it's Friday, that Brenda Fleming will be having a birthday. So I just wanted to wish her a happy birthday.
Thank you so much. I'm turning 90 tomorrow. Thank you so much for the birthday cheer. I appreciate it.
A young 90.
Not doing too bad for 90, right?
Not too bad at all. Well, happy birthday to you, Ms. Fleming. We're excited to celebrate. You've dropped many things on us this week in the last 2 days, so we will send you off in style. Don't worry.
Thank you, ma'am.
So thank you for that reminder, Senator Gaines. It's always important to remember the humanity of the work that we're doing and the people that we serve and that we work with. So I appreciate those comments. All right, so let's continue going into the first item on the agenda. Ms. Taylor?
All right, our first order of business is an announcement regarding the public teleconference participation. Good morning, and thank you for joining today's Board of Equalization meeting via teleconference. Throughout the duration of today's meeting, you will primarily be in a listen-only mode. As you may know from our public agenda notice and our website, we have requested that individuals who wish to make a public comment fill out the public comment submission form found on our additional information webpage in advance of today's meeting, or alternatively, participate in today's meeting by providing your public comment live. After the presentation of an item has concluded, we will begin by identifying any public comment requests that have been received by our board proceeding staff, with the AT&T operator providing directions for you to identify yourself. After all known public commenters have been called, the operator will also provide public comment instructions to the individuals participating via teleconference. Accordingly, if you intend to make a public comment today, we recommend dialing into the meeting on the teleconference line, as the audio broadcast on our website experiences a 1 to 3 minute delay. When giving a public comment, please limit your remarks to 3 minutes. We ask that everyone who is not intending to make a public comment, please mute their line or minimize background noise. If there are technical difficulties when we are in the public comment portion of our meeting, we will do our best to read submitted comments into the record at appropriate times. Thank you for your patience and understanding.
All right, thank you, Ms. Taylor. I want to thank the work group members, my fellow co-chair member Vasquez, board members, colleagues, of course, the executive director and the Board of Equalization executive team, all the stakeholders and the members of the public for their hard work and their important input on the issue of Remote Assessment Appeals Board. And from the start, this work group was established to address the impacts of COVID-19 and provide guidance to local assessment appeals board. The health and safety of taxpayers and all AAB team members remains our #1 priority in providing guidance to the remote hearings. Another significant priority is to ensure the due process rights of all parties, making sure that they are preserved regardless of an in-person meeting or a remote meeting. So we are looking forward to the presentation today by the executive director on the proposed LTA that reflects the consensus of the work group. We are also looking forward to receiving the evaluation of the proposed LTA by the work group members. We've reached consensus on many issues, but there are still several unresolved differences that remain among the work group participants, and that's okay. We will continue to work together to work through them. I'm confident that we will make progress in the work before us and provide an opportunity for the work group participants to address some of the unresolved matters. And so with that said, colleagues, before I proceed to the agenda, are there any opening remarks from the board members? And first, I'd like to pivot and start with the co-chair, Member Vasquez.
Yes, thank you, Madam Chair, and thank you for all your work as well. And I'd just like to thank all the staff and specifically all the stakeholders that have participated with this over this period of time, because I know it was difficult, especially given the restrictions we had with COVID. But I know many of you had to block off time from your schedules. Really appreciate that. So I just want to echo the same support and thoughts that our chair just mentioned. And also just wanted to thank our staff, not only within our both districts, District 3 and 2, but also with the BOE staff to get us to this point, and looking forward to hopefully coming up with some consensus on most of these items. I know there's still some issues we still need to work out, but looking forward to the discussion that'll take place shortly. Thank you.
All right. Well, thank you, colleagues. Is there anyone else like to make any remarks? I don't see any hands. Okay. So before we proceed, I want to clarify for the public and the work group participants our agenda for the day. First, we will receive a presentation from the executive director and other executive team members on the proposed LTA. Next, we will receive a presentation from the executive director on any communication received related to the proposed LTA, then followed by received comments and feedbacks from the taxpayer representatives and the counties. And then we will follow that up with an opportunity for work group participants to address any non-consensus items with the goal of resolving these items. Finally, we will provide an opportunity for comments and feedback about additional guidance needed. And I trust this delineated process, which is consistent with our agenda today, will assist us in having a productive meetings. So, colleagues, with that said, let's proceed with today's agenda. Ms. Taylor, please proceed.
Thank you. The first agenda item is M2, update impact of public calamities on property tax administration, county boards of equalization, assessment appeals boards, AAB, remote hearings. Our first sub-item is A, report on proposed LTA based on consensus language established by the work group at the November 2021 board meeting. The speakers are Brenda Fleming, Executive Director, California State Board of Equalization, David Young, Deputy Director, Property Tax Department, California State Board of Equalization, and Richard Moon, Tax Counsel, California State Board of Equalization.
Thank
Chair
you, Ms. Taylor. Thank you. Good morning, members, and Honorable Chair Cohen and members and our invited guests. First of all, thank you all for members, first for your leadership in this area and really moving us forward to try to do our role in contributing to the success of our AAB hearings during these pretty challenging times. Today, our presentation of the LTA is mentioned on the consensus items, and some of the language where staff are asked to kind of revise it a bit more is going to be presented to you from Mr. Young and Mr. Moon, and they're going to walk you through what we've accomplished so far. I think the plan for today, after hearing these comments, is just to hear them, and then as the chair facilitates with the discussion, we'll have the comments come throughout the remainder of the discussion. That said, I won't delay any further. Mr. Young, if you would begin the presentation. Thank you.
Thank you, Ms. Fleming. Good morning, Chair Cohen and honorable members of the board. David Young here, Deputy Director of the Property Tax Department. So I will present our redraft of our LTA on guidance for remote hearings in as it is impacted by COVID-19. So as already mentioned, in November of last year, we had a meeting and staff was asked to redraft our LTA on that, and that is LTA 2021-002. So I used that as a starting point in order to incorporate all the components that were one, consensus items. They were incorporated in basically an underline. The items that were struck out that were deleted were denoted in strikeout, and then there were 4 items that were consensus items, and there was 1 item that was a consensus in concept, but staff was asked to redraft it for clarity, and so that was actually put in italics. So with that, if it pleases the board, I will go ahead and give a brief run through page by page as to what exactly we did. So I apologize for not being able to pull this up on the screen, but I will go through each page and highlight the areas where we did make changes. So the very first page on our draft that is available, if you click on M2A, that draft should be available to you. We did take one liberty there, and we added on the note portion in about the center of the page, we added this current draft, the last LTA draft, that this actually, if adopted, this draft supersedes our last one, and that is the LTA 2021-002, and that was published in January 13th of 2021. So if everything is moved forward, then this would also supersede that. The next item that we did change was a consensus item. If you will be so kind as to change is look on page 2 under the rights of hearing participants. The language there basically represents the consensus item for that topic. So we struck out certain portions of that and included the language that was agreed to. So for brevity's sake, I will not read the whole paragraph unless you want me to. So that is verbatim the consensus item that was agreed to in November. The next paragraph, if you look on page 2, there is the paragraph that begins the appeals board. That is a redraft of an item that had consensus in concept, but we were asked to rewrite that language. Since that is new language that staff wrote, I will go ahead and read that one. It is, the appeals board may also grant a good cause postponement for health concerns stemming from the COVID-19 pandemic if the applicant provides a written agreement to extend and toll indefinitely the 2-year limitation period provided in RTC section 1604, subject to termination by 120 days written notice by the applicant. New sentence, any postponement request which does not procedurally comply with Rule 323, parentheses, open parentheses, both of right and discretionary, close parentheses, need not be granted by the appeals board. So that is the staff language. Moving on, the last paragraph under rights of hearing participants and underline is actually the agreed to language verbatim, with the exception of one addition that staff put in there for clarity. Under HIPAA, staff actually spelled out that HIPAA is the Health Insurance Portability and Accountability Act. So since that was not mentioned earlier, we inserted that in there. But other than that, it is verbatim. Moving on to page 3, the other agreed to item under the document submission, it is on the upper 1/3 of that page. There is strikeout language. We struck out the word county and inserted appeals board, and that is done twice there, and that is indeed a consensus item. It is incorporated in total there. Moving on to page 4, under scheduling efficiencies and notices, staff inserted the agreed to language about 2/3 of the way down. It is a paragraph. It begins with counties are encouraged to develop written protocols and procedures. Once again, that was consensus language, and staff placed it in our revised LTA verbatim as adopted. Moving on to page 5, under the heading of information requests. There is strikeout language under the first paragraph. Clerks of the appeals board should deny applicants that portion was struck out, and that is once again consensus language from November. We move down to the third paragraph under information requests. Once again, strikeout for language that was agreed to be removed, and underline for language that was agreed to be inserted. So that is the draft that is before you. The items that did not have consensus, as directed, staff did not include any revision to that language. And the rest of the LTA remains as drafted and published in January of 2021.
Thank you.
Of course, I'm available for any questions you may have.
Let's see, colleagues, are there any questions for Mr. Young? All right, Mr. Young, I don't see any. Thank you for your presentation.
Of course.
We can go on to Mr. Moon.
Hello, members of the board. Richard Moon with the legal department. I actually don't have anything to add to Mr. Young's presentation, only that we are happy to continue to help the work group in whatever way we can, as directed by the board and the executive director. So thank you.
All right, great, thank you. Let's see. Ms. Taylor?
Yes, Chairman.
Did you call the next, I think the next sub item?
Yes, I think we do need to take public comment.
Oh, yes. Okay, thank you.
AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Okay, ladies and gentlemen, if you'd like to make a public comment, please press 1, then 0. Once again, please press 1, 0. And we have no one in queue at this time.
All right, thank you very much.
Our next sub-item is B, report on communications received regarding the proposed LTA. The speaker is Brenda Fleming, Executive Director, California State Board of Equalization.
Thank you, Ms. Taylor. Members, to date, we have received 3 submissions. Since the November 2021 meeting, we have received letters dated January 21st, 2022 and January 25th, 2022 from the clerks, CACEO, and a letter dated January 25th, 2022 from CADA. I believe all submissions have been attached to today's agenda and have been made available to you for today's discussion. That concludes this portion of my presentation, members. Thank you.
All right. Collins, do you have any questions or comments? All right, any work group members, do you guys have any questions or comments for Ms. Fleming? Okay, seeing none. Ms. Taylor, do we have any public comment on this item?
We do not have any written comments. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Okay, once again, if you'd like to make a public comment, please press 1, then 0. 1, 0. And we have no one in queue at this time.
All right, thank you very much. Ms. Taylor, let's call the next sub-item.
The next sub-item is C, follow-up evaluation of proposed LTA, taxpayer representative perspectives and clarification of the LTA. The speakers are Mark A. Aprea, Principal, Aprea and McKelly Associates on behalf of CADA, Richard Ayub, Partner, Ajalat, Polly Ayub, Matarisi and Brogi on behalf of CADA, Chris K. O'Neill, Shareholder, Greenberg Traurig on behalf of CADA, Scott Donald, Vice President, Marvin F. Poor and Company on behalf of CADA.
All right, thank you very much. Gentlemen, welcome.
Thank you, Madam Chair.
Thanks, Madam Chair.
All right, so let's go ahead and get started. We'll start with Mr. Aprea first, then we'll hear from Mr. Moore, then Mr. Marsh.
Madam Chair, amongst the folks from the California Alliance of Taxpayer Advocates, we would like Mr. O'Neill to take the lead for us on this item, and so I'd like to hand it over to Mr. O'Neill.
Okay, sounds good. Mr. O'Neill, welcome. The floor is yours.
Thank you. And before I start, let me just say your reception of me might be a bit glitchy. If need be, I may have to turn off my video in order for you to hear me. Would you let me know if you're not hearing everything I'm saying?
Certainly we will. Thank you.
So thank you for the time this morning to address the draft LTA that was issued last week. We have spent some time studying this as a group, CADA has, and in particular our work group has. We are in agreement with almost everything that is here in the draft that was issued last week. And the only area that there continues to be a little bit of concern about is on page 2, the paragraph or the section called Rights of Hearing Participants, which has been an issue all along the way. In fact, we are satisfied with almost all of the language in this portion. There is one item which we've had some discussion about. In the first paragraph, under that heading, Rights of Hearing Participants on page 2 of the draft LTA, the 4th line carrying over to the 5th line, the words "as a general matter." Now, I have discussed with Mr. Aprea, apparently he and another CADA representative in November were in agreement with this language. And at the risk of throwing Mr. Aprea a little bit under the bus here, we're a little concerned because language such as a general matter would mean that there could be exceptions to the rule. And we would ask that the board consider whether the words "as a general matter" in that paragraph should be removed. That would make the sentence much more direct, and I'm not sure it's really necessary. We're not sure it's really necessary to have "as a general matter" in there. Regarding the rest of the language in that section and in the rest of the draft LTA, we are satisfied with the way it's been presented by Mr. Young. We believe this is a good presentation, a fair presentation of what needs to occur with regard to remote hearings. Before I turn the matter over to maybe another one of my colleagues, a couple other items I would like to bring up. One is we're aware of the 2 letters that the CACEO issued on the 21st and the 25th of this month. As you know from our letter, CADA's letter yesterday, we have a lot of disagreement with the proposed language that was in the CACEO's January 21st letter. However, we think it's possible that the CACEO may have retracted that letter when they issued a letter yesterday, which is much shorter and has only a few items. And if we should get into a discussion of the January 21st CACEO letter, CADA would like to reserve some time to discuss that letter at length. But assuming that letter has been retracted and focusing only on the letter that the CACEO issued yesterday, there are two additions or changes that the CACEO is recommending here. One of them is to the rights of hearing participants section. And that's on page 2.
Mr. O'Neill.
Yes.
We're actually starting with the positive side of things, Mr. O'Neill, where we have consensus. There is a special time on the agenda for where we don't have consensus.
Okay.
And so I was wondering, maybe we could either pivot to your remarks where there is consensus, or but we will certainly hear you out on areas that we need to work on. Is that fair?
Yeah, that's very fair, Madam Chair. Then in that regard, we're going to disagree with the language in that letter. So as far as where there's consensus, we are in support of the draft LTA as issued last week and reported by Mr. Young, with the exception that we believe the wording "as a general matter" in that paragraph on page 2, in the middle of that page 2, should be removed. Otherwise, we're in agreement with all of the other language, all the other changes, and all of the other wording.
See, no, wasn't that easy? Let's start with easy first, and then we'll get into the meeting, more substance stuff. Thank you. I appreciate you accommodating my request. And so for the other speakers, just moving forward, we want to hear where we do have consensus so that we can have it on the record. Okay. Thank you, Mr. O'Neill. Does that conclude your remarks?
That concludes my remarks, and I believe that concludes the remarks by CADA.
Okay, great. Next speaker. Who's our next speaker? Mr. Ayub, is that you?
Yes, Mr. O'Neill covered everything, Madam Chair.
Okay.
We had the, 2 or 3 of us are here because of what we were looking at in the January 21st letter. Now that there's been a substantial retrenching of that position by the CACEO, I think Mr. O'Neill covered all we need to cover at this point.
Okay, and Mr. O'Neill, correct me if I'm wrong, you were speaking on behalf of all CADA, so I don't need to pivot back to Mark Aprea.
That is correct.
Okay, all right, great to know. All right, so forgive me, I don't have an updated list of speakers. I'm not sure who to call on next. So if you're a speaker, just go ahead and jump right on in.
Chair Cohen, this is Ms. Taylor. The speakers that I called, that is who was planned for the sub-item C. So you could open it to the rest of the group should you desire.
All right, let's do that. Let's open it up to the rest of the group. See if there's any comments from any other work group members, any colleagues, Any comments? I didn't think so. This is the easy part. So let's go ahead and pivot and maybe take some public comment.
Certainly. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Okay, if you'd like to make a public comment, please press 1, then 0. 1, 0. And we have no one in queue at this time.
Okay, great, thank you. Ms. Taylor, could you please call the next?
Yes. The next sub-item is D, follow-up evaluation of proposed LTA, county perspectives and clarification of LTA. The speakers are Alina Kasparian, Acting Chief, Assessment Appeals Division, Executive Office of the Los Angeles County Board of Supervisors, Thomas Parker, Deputy County Counsel, Los Angeles County, on behalf of the Los Angeles County Assessment Appeals Board and CEO. Ann Moore, Chief Deputy Clerk, San Diego County Board of Supervisors, Marcy Berkman, Retired Deputy County Counsel, Santa Clara County, Kathy McClellan, Assistant Clerk of the Board of Supervisors, Sacramento County, Kyrene Gonzalez, Deputy Clerk of the Board of Supervisors, Sonoma County, the Honorable Leslie Morgan, President, California Assessors Association and Shasta County Assessor Recorder, Ernest Dronenberg Jr., San Diego County Assessor Recorder Clerk, Edward Yen, Assistant Executive Officer, Los Angeles County Executive Office of the Board of Supervisors.
Okay. All right, thank you. All the presenters, are you ready to present? All right, Ms. Kasparian, we're going to start with you, okay? Good morning, welcome.
Thank you so much. Good morning. Good morning, Chair Cohen and members of the board. First, I'd like to thank the board for giving us the opportunity, of course, to participate in these meaningful, productive discussions we've had with regards to the LTA, and for allowing us to share our perspective on some of the impacts that the LTA has had on AABs in particular. And of course, thank all the executive staff for all the hard work. I know we've had many revisions and drafts of this LTA, and I know it can't be easy. So thank you guys for all of that. I'm also thankful to John and Tom for coordinating all of this through CACEO. Though it's been tough, and we've come together, I think, with the willingness to compromise on some of the language and in an effort to kind of streamline this whole process. So thank you to both as well. With that said, I do have some points of perspective I'd like to make on behalf of LA County. And I do want to highlight that first, LA County has not, the Board of Supervisors meetings have not resumed yet in person, and neither have Assessment Appeals Board hearings. So we've solely relied on remote hearings to conduct business. I also want to point out that, I think we've stated time and time again that we are in no way here for a one-size-fits-all approach. I think that's unrealistic. And that we have a willingness, we're more than willing to actually provide taxpayers with the hearing platform of their request. Whether it's in person or remote, we believe that due process being afforded is important in either of those platforms. So again, we have been accommodating any request for in-person hearings until once we resume in-person hearings, and are in no way forcing those who to continue with remote hearings. I do want to also point out some fun facts. Out of the approximate 26,000 some cases that we've scheduled since we've began with remote hearings, which is an increase from any other year that we've ever scheduled using in-person hearings, only 2% of our appeals of those applicants requested in-person hearing, of which 90% were made from tax agents. So a lot of the taxpayer feedback that we've received has actually been quite positive. Of course, you're going to have a handful who prefer in person, but the feedback that we've received is that they prefer not to drive downtown. Traffic, of course, especially in LA County, saving on gas and parking, And many have expressed that the remote hearing platform has actually been less intimidating, especially to our, taxpayers who are mom and pop and represent themselves and are not very familiar with this process. So we've been very happy and pleased to, of course, serve our taxpayers and our constituents. Another thing I want to provide, to include, I think we've shared previously, is any taxpayer who has requested in person or has needed accommodation. We've also made that accessible through one of our commuter rooms we have here, where we've brought them in to conduct the remote hearing if they don't have access to the technology. So we've received pretty good feedback about that as well. We're happy about that. LA County also has approximately about 40,000 open appeals, and based on historical data, this is not unusual, and definitely not something that we would say would be resolved overnight. The RMT code change that allowed us to, run as many assessment appeals boards as necessary has helped us since we've expanded the number of hearings that we're running. Previously we were running about 3 to 4 hearing boards, but on average, when I checked data, it was usually about 3. We are now running about 6 hearings, and that's solely been due to remote hearings because of the flexibility. We have limited space here, limited hearing rooms, and a lot of resources and staffing that we've had to bring in, to conduct these hearings, and telework and remote hearings has definitely helped with that. Our goal is to eventually run 10 hearings so that we may, facilitate this whole process and ultimately afford due process to taxpayers, which is giving them the timely hearing that they deserve. Another thing I would like to point out is...
Excuse me, Ms. Kasparian. The testimony during this time should be just limited to the proposed LTA.
Okay.
There'll be other times for you to go on and other subject matters. Okay. We need all the work group participants to limit their current testimony to the proposed LTA.
Okay.
Thank you.
Thank you so much. All right. I think that's pretty much, we're just happy to work together to come up with the consensus language. So I just wanted to say thank you for that.
All right. I appreciate that. Thank you. There'll be there's another point in time on the agenda for us to move forward with other items. Okay.
Thank you so much.
Yep, absolutely. So with that, let's call Mr. Thomas Parker.
Good morning, Madam Chair and honorable members of the Board of Equalization. I am the representative today in lieu of John McKibben, representing the CACEO, as well as answering any legal questions that may come up during the various discussions today. On behalf of the CACEO, I wish to thank the State Board and its staff for its hard work and its important attention to these issues to try and resolve them. The CACEO has, of course, reviewed the proposed LTA. We agree with the consensus points as set forth in the November 2021 memorandum put out by Chair Cohen and Workgroup Co-Chair Vasquez. At the appropriate time, we would like to offer some minor clarification or tightening language that we believe is consistent with the consensus points as stated by the State Board of Equalization. And I would also like to make clear, as Ms. Kasparian referred to a moment ago, it took very serious consideration of the CACEO membership to reach the consensus position that is now adopted in our January 25th, 2022 letter. We did so in the spirit of attempting to resolve these issues in a reasonable way, and we hope that the State Board will take our compromise position in that light. I will speak at another point in time on the exact language differences. Thank you very much.
Appreciate it. Thank you. Next speaker is Ms. Ann Moore.
Sorry, you'll have to forgive me. I'm in the office where we have to wear masks most of the time still. I would like to echo what everyone else has said about the gratitude towards everybody who's worked through this. I know it's been really challenging, and I would like to thank my fellow members of CACEO as well, because echoing Tom's point, we have such a wide variety of counties with different needs, and so we took it very seriously, making sure that what we agreed to will represent the needs of all the different counties. So I would just like to note how carefully we have considered this before coming to agree on these consensus points, but we do want to work together to ensure that the language meets everyone's needs. So thank you.
Thank you. Next speaker is Ms. Marcy Berkman. Ms. Marcy Berkman.
Hi, thank you. Sorry, I'm getting a message that video is not supported by this browser. So
That's okay, we can hear you, Marcy.
Voice only. I appreciate all the board's hard work over the last many months on the LTA and throughout the pandemic on this. I'm in agreement with the LTA. There is one holdover place in the beginning of the taxpayers' rights of the participants' rights section where the word taxpayer was used. That should be participants, and I believe that's just a typographical carryover from the initial LTA last year. But both the assessor and the taxpayer have equal due process rights before their board. They're both participants before the boards. So I would just suggest that one word change in that one place. Okay. Thank you.
Thank you. Kathy McClellan. Kathy?
Sorry, I was turning on my video. Thank you, Chair Cohen and members of the board for allowing me to be part of the conversation, allowing Sacramento County to participate. I appreciate all the hard work and everyone working together to try to come to a consensus on all items. I know we're making a lot of progress as time goes by, and I don't have anything really to add at this point concerning this, but I just wanted to say thank you, and I believe we're making progress and look forward to full consensus soon.
Perfect, thank you. Kyrene Gonzalez.
Good morning. Thank you, Chair Cohen and members. I do very much appreciate you making the time to speak with us today. I will work on being brief. We, as a work group, have worked very, very hard at reviewing the LTA and revised language. And there are only 2 non-consensus items. The rest of the LTA we have come to consensus on. The one that we have not.
Ms. Gonzalez.
Yes.
We're only taking the consensus at this time.
We'll I thought this was non-consensus. I appreciate it.
We'll hear non-consensus shortly.
I apologize. Okay. Yes. Thank you so much.
No apology needed. Okay. So let's see. We've got the Honorable Leslie Morgan next.
Hi. Good morning, Chair and members of the board. I guess the best thing I would say here is, as the association is very appreciative of the efforts going into this, the reminder is we're all elected by our constituents, and we all have that understanding of what our county's needs are. Obviously, I'm much different than LA County. So when the board and on this, we're working towards getting a consistent process put in place, and yet for the overall oversight of it rather than the individual needs of each particular county. So this has been a good example of us coming together on that. The assessor's focus has been on how it lays out maintaining the process of that appeals board. And for us, most of our communications take place outside of the appeals boards. The majority of them get settled without being part of the appeals board. So, we focus on those areas where this is about how we navigate the sharing of information between the boards. And so far, This has been a good process with all the participants coming together. I know there are a couple of areas where, there has been, I guess, some slight disagreements, but I'd just like to focus you all on the fact that we're all representing our taxpayers. We're all trying to build up the effort to keep communication going with our taxpayers, and how best to allow those individual taxpayers or their agents to present information in the platform where we might have disagreements still about the overall value. So overall, I'd say thank you to everybody involved. And if there's more discussion on any of these remaining issues, we can speak up then.
Great, thank you. All right, and last we have Honorable Ernest Dronenberg Jr.
I hate to be last, but this will be the last time you'll hear me today. Leslie and I have discussed this, and actually, we want the assessor's president to speak for us. So even though my name was there, Leslie makes the comments for the association. So and
completely understood and understand that. Thank you. Okay. Well, thank you to the presenters. Colleagues, do you have any questions, any follow-up or comments on the issue? No, pretty straightforward. All right. Ms. Taylor, do we have any public comment on this issue?
We do not have any written comments, but I'll reach out to the moderator, AT&T moderator. Please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Okay. If you'd like to make public comment, please press 1, then 0 at this time. 1, 0. And we have no one in queue at this time.
No one in queue. Okay, great. Thank you very much. Ms. Taylor, could you please call sub-item E?
Certainly. Sub-item E is follow-up on the impact of possible transition plans for in-person AAB hearings. We will use this agenda to address non-consensus matters from the prior work group meeting. Although there are some of the work group participants' names may not be listed, their organizations are listed, and feel free to comment to ensure a robust and meaningful dialogue. The speakers on this sub-item are Thomas Parker, Deputy County Counsel, Los Angeles County, on behalf of the Los Angeles County Assessment Appeals Board and CACO, Honorable Ernest Dronenberg Jr., San Diego County Assessor Recorder Clerk, Mark Aprea, Principal, Aprea and McKelly Associates on behalf of CADA, Richard Ayub, Partner, Ajalat Poli Ayub Matarisi and Brogi on behalf of CADA, Chris O'Neill, Shareholder, Greenberg Taurig on behalf of CADA, Scott Donald, Vice President, Martin Poor and Company on behalf of CADA, David Young, Deputy Director, Property Tax Department, California State Board of Equalization.
Miss Taylor, can you just excuse me just for a second, please? There is something that I need to. Board, at this time, I'd like to receive a motion from you. My apologies, my notes are all not together. So colleagues, I'd like to receive a motion from the board on the proposed LTA so we can accept this portion of it. There is consensus, and so that we can continue to move forward. Is there a motion on this?
So moved.
Thank you very much. I appreciate that.
Second.
Thank you very much. I appreciate the second. Ms. Taylor, could you please call the roll?
Certainly. The motion on the floor is to accept the LTA as presented. Chair Cohen.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Vasquez.
Aye.
Deputy Controller Stowers.
Aye.
The motion passes.
Thank you very much. Okay. Now let's call sub-item E.
All right, I will start from the top. Sub-item E is follow-up on impact of possible transition plans for in-person AAB hearings. We will use this agenda to address non-consensus matters from the prior work group meeting. Although there are some of the work group participants' names may not be listed, their organizations are listed, and please feel free to comment to ensure a robust and meaningful dialogue. The speakers on this sub-item are Thomas Parker, the Honorable Ernest J. Dronenberg Jr., Mark Aprea, Richard Ayub, Chris O'Neill, Scott Donald, and David Young.
Thank you. Welcome again, Mr. Thomas Parker. We'll start with you.
Thank you, Chair Cohen. I appreciate the opportunity to speak before your board again. There's an area of non-consensus regarding the issue of affirmation in the LTA of the local AAB's authority to enact a local rule on document submission in remote hearings. The current LTA, which has just been approved by your board, does not have any new language in the language of the LTA. And the CACEO did respectfully submit a somewhat proposed language. We fully acknowledge, and we hope the state board acknowledges, that we have under the Constitution, Article 13, Section 16, the authority to enact procedural rules at the local level. And assuming for the moment that I am correct in concluding that not only my association but the state board would agree with that statement as a matter of law, we would hope to get affirmation, notwithstanding the fact that it is possible to make the argument that affirmation of that authority is a bit of a redundancy or unnecessary to be said. Notwithstanding that possible viewpoint, we would feel that the LTA affirming our existing authority under the Constitution would further reinforce and encourage compliance by all parties, taxpayers as well as assessors, with any local AAB rules that do state whatever procedural requirements on the submission of documents electronically for upcoming remote hearings. Thank you very much.
Thank you, Mr. Parker. Mr. Dronenberg, will you be speaking on this item?
No, I think that's going to be me again, Malia.
Not a problem. That's what I thought. You're welcome.
Yes.
The floor is yours.
Yes. And I guess the biggest thing, alluding to what I said earlier, is that I'd like to emphasize like what Thomas Parker just said, and that is each of these appeals boards, have to set the rules for what fits their constituents' needs. And so I think it's just important to understand that if you take out and modify the language too much, you could end up backing an appeals board into a corner of, always having to accept a rejected reason or always having to comply in a certain way, where that appeals board may, as they stated, unless it's infeasible. I think they're trying to give themselves the leeway to have the ability to work with the taxpayers, with assessors' offices, because we all are, in a world where we're learning remote connectivity. As Board Member Gaines stated yesterday, we're all getting used to this, whether it's our courts, our BOE meetings, and we're getting better at this all the time. So I would just caution you in the generality that both for the assessor and for how we work with the appeals boards and setting up these meetings and determining which taxpayers are going to are probably the most prepared to meet remotely as compared to those who we really would encourage to meet in person for, because like up here in Shasta County, we have a large part of our population where they just don't have the same connectivity. So we would be working with our appeals boards to make that determination as to when it's appropriate to have remote connectivity as opposed to in person. But again, every county is not the same. So overall, as assessors, we want to be supportive to allowing our assessment appeals boards to administer the policies and procedures of those meetings, and focus on how we exchange information, present our cases, and do so in a way that's fair to everybody involved.
Let me interject here and just see if there's anyone that has any other county representatives or representatives that would like to speak to the language change proposed by LA County. If there's anyone that'd like to speak. If not, okay.
This is Chris O'Neill, Madam Chair. I would like to speak to the point about the constitutional provision.
Yes, please go ahead. And you're representing CADA, correct?
Representing CADA. Chris O'Neill representing CADA. Yes, thank you, Madam Chair. Citing the law is always good. I'm not sure that it's essential here. The constitutional provision is known by all. I would ask, though, that if we're going to cite the law, then we should cite it accurately. And what's written in the letter that the CEO submitted yesterday says that counties possess the constitutional administrative authority to enforce local appeals board procedures and rules. And the Constitution doesn't use the word enforce. Mr. Parker used the word enact, which is more accurate, but I'm reading the constitutional provision right now. This is section 16, and it says the boards have the power to adopt rules and notices of procedure. So, which of course we all would agree with. It's in the Constitution. So I guess I go to 2 points again. One is it necessary to include a constitutional provision and reference to it here? And I don't think so. CADA does not think so. But if the board believes it is, then we should accurately cite the Constitution. And the word enforce is not in the Constitution. The word in the Constitution is adopt.
Okay.
That's the only comment I would have on CEO's suggestion to add this constitutional provision.
Thank
paragraph.
you. All right. I appreciate that. We will continue. I think, Monica, I think I cut you off. I'm not sure. Mr. McNeil, do you have any consensus language to propose?
I don't think it's necessary to include this paragraph at all. We could just leave the draft as adopted by the board already.
All right, fair enough. Okay, let's continue moving. Let's see, where did I leave off?
Chair Cohen, perhaps Scott McDonald?
Yes.
Madam Chair, this is Scott Donald with Marvin Poor Company. Chris O'Neill has spoken on behalf of CADA, and I have nothing further to add at this time.
Okay.
Thank you so much.
Are there any other CADA representatives that would like to speak at this time? Or
Madam Chair, I do have one comment to raise. Chris O'Neill again for CADA.
Okay.
I don't know if any representative of the CEO has brought this up yet. And if so, I will remain silent. I know the letter that was submitted by CEO yesterday talked about changing the word taxpayers right in that paragraph on page 2, middle of page 2, to parties right. CADA would ask that that word not be changed. And if the issue is there, I would be happy to address it right now, Madam Chair. Otherwise, I'll remain silent.
All right. Give me a second. I think I think we're going to ask you to remain silent. Mr. O'Neill, your words, not mine. And we will will give it back to you at a later time. Okay. Are there any other comments? Is there anyone from the CACEO that would like to get on the record and share their thoughts? The CACEO representatives, are you guys on?
I see Ms. Berkman has her hand raised.
Please acknowledge her.
Hi, thank you. With regard to the word taxpayers or participants, I think, as I mentioned earlier, the word taxpayers went in the original draft of the letter, but is, to my mind, as a former AAB counsel for decades, more appropriately participants, because both the taxpayers and the assessors are parties that appear before the AAB. Both constitutionally have the same due process rights, and both have the exact same rights in, preferences before the board of whether they appear in person and remotely. And then also with respect to the phrasing as a general matter, it is easy for me as someone who was AAB board counselor for decades to foresee instances in which the taxpayer may want a remote hearing and the assessor may want an in-person hearing, or vice versa. The taxpayer may want an in-person hearing and the assessor may prefer a remote hearing. And in those cases, the AAB is going to have to exercise its discretion of which way it's going to proffer the hearing. And one party doesn't get to control over the other party. They both have equal rights to express their preferences. And where the AAB can, and that appeals board does offer remote hearings, and both parties want remote, that's simple if it works for the AAB's calendar. Where the AAB offers live hearings and both parties want live hearings, and that works for the AAB's calendar, that's simple. But where the parties disagree and or it doesn't work for the calendar, the AAB and its clerk is going to have to make the decision. And that's why I think the word taxpayer should more appropriately say participant in that one sentence, and why it would be good to leave as a general matter in the letter as the board put it that way. Thank you.
Okay, Mr. O'Neill, does you or Kata have any response to Ms. Berkman's comments on the word parties versus taxpayer?
Yes, Madam Chair. Actually, Ms. Berkman has raised two issues in her comments. One is changing the word taxpayer to parties, as in the CACEO's letter. And the second is she has raised whether or not the wording as a general matter should be included. I'll address the first item, whether the word taxpayers should be replaced with parties. And I'll allow my colleague, Mr. Ayub, to address the second comment by Ms. Berkman, going to the wording as a general matter.
All right.
So focusing first on taxpayers versus parties. If we read the paragraph in the LTA as just adopted by the board, the consensus items, what precedes this sentence is a reference to the board's property tax rule 302A1, which says ensures that all applicants are afforded due process. So the context here is applicants. I think that is the first reason why the word taxpayers should be included, not parties. Let me add to that, however. It is only assessment appeals board proceedings only take place if an application is filed. Taxpayers, for the most part, have the burden of prosecuting the assessment appeal application. Taxpayers almost always have the burden of proof in those proceedings. They have the burden of presenting evidence first in those proceedings. There is a presumption that the assessor is correct, and the taxpayer has the burden of overcoming that presumption in most of these proceedings. It makes sense that the taxpayer would have the right to choose the forum, that the taxpayer's desire for a forum, whether remote or in person, is paramount. I think that
Mr. McNeil, Mr. O'Neill, are you? I think you're going into the general matter language.
I'm going into, no. I'm sticking with that. I believe that the word taxpayer in that sentence should remain as adopted by the board. I do not think that it should be replaced with parties.
Okay.
And I'll stop with that, and I'll turn it over to Mr. Ayub for his discussion of as a general matter. Mr. Ayub?
Okay, well, hold on. I want to hear from Richard Moon first, the comment on parties versus taxpayer.
Okay.
I could hear from Mr. Moon.
Hi, Madam Chair, Richard Moon with the Legal Department. It's with regard to that particular language. Well, first, I guess what I would say is I know that this, although the CEAO's letter used the word parties, I believe Ms. Berkman used the word participants. And I believe if it's the board's pleasure to make a change in that location, that the word participants may be better, and that's because that same word participants is used already in the next sentence, and the entire paragraph is titled Rights of Hearing Participants. And so although Mr. O'Neill is correct that Rule 302 does ensure that all applicants are afforded due process, the tenor of the entire paragraph is the rights of hearing participants. And so while I don't think from a legal perspective it would be incorrect to have taxpayers, of course, it would also not be incorrect to change that to participants.
Question, if I could?
Yes. Go ahead.
So, could you define participants? That would include taxpayers, and would that resolve the issue?
I'm sorry, Mr. Gaines, was that a question directed to me or to the parties? Or to the work group?
I think it's directed towards you, Mr. Moon.
But I'd like to hear from Kata, Mr. Moon and Kata. So if we're looking for consistency with the word participants, could you then define participants to include taxpayers, and does that address the issue that Kata has brought up?
Well, from my perspective, the word participants would include taxpayers because they would be the ones that would be filing the applications, and they would be parties to the.
Why wouldn't you define participants?
I suppose you could, but there would be language that would need to be added here to make that definition, and I'm not sure if the wish of the work group was to expand the scope, I suppose, to do that or not.
I'm just trying to find clarity, and I'd like to hear from Kata because I don't know if that helps resolve the issue that they're raising, while at the same time addressing the comments by Ms. Berkman.
Mr. Gaines, Member Gaines, this is Chris O'Neill on behalf of Kata. I believe Kata reads this paragraph and the word participants in the paragraph to mean the participants in the Assessment Appeals Board proceeding, and in this context, that would be the taxpayer or the applicant, and also the assessor or the assessor's representative. I think the term covers both sides in the proceeding.
Okay, what term?
Participants.
Participants. Okay. All right. So you're comfortable with that?
It would have the same meaning. I think though there's a question here that comes to mind, and that is, and it really isn't firmly addressed in what I've read, as to whether the board of the Assessment Appeals Board should be considering the concerns of an assessor's office or an assessor as to whether the assessor wants a remote hearing or an in-person hearing. Now,
sure.
Now maybe the assessors really haven't taken an active position in these discussions, and not as active as CACEO, and maybe that's the case. It seems to me that the rights of hearing participants and due process, when we're talking about rights, we mean due process, have been focused on applicants or taxpayers. So, that hasn't been the focus of the discussion. It doesn't appear to be the focus of this paragraph necessarily. Granted, I will agree with you, though, participants would include assessors.
Let me interject here. I don't want to expand the discussion because I think we're close to getting consensus on this item. I want to poll all parties. Here's my question. Do we all agree that that we could change the word to participants?
No.
I heard a no. Who was that no from?
Madam Chair, this is Richard at you. Let me see if I can put a little distinction in here. It goes to Board Member Gaines's point.
Okay.
Use of participants later on allows for the rejection of a remote hearing if one desires either party desires an in-person hearing. Mm-hmm. But the right of the taxpayer to initially choose to meet remotely or in person is what I believe Kata's position is trying to preserve. That if you change that to participants, then we create the issue that Ms. Berkman talked about, where parties disagree and then who chooses. That's why and you're right, Madam Chair, this does go into the as a general matter kind of language a little bit. Mr. O'Neill has made the point, I think it's quite right, that the applicant initiates the assessment appeal. The assessor has a presumption of correctness. He's put forward the assessment, and the burden is on the taxpayer to go forward and present evidence in an assessment appeals hearing. We believe strongly that by initiating the action, you should be able to initiate the action in the form that you desire. Now, as was pointed out earlier, a lot of people are electing remotes, and it's only a few that are electing in person. But those that are electing in person, I think should have that right to prevail and have that honored as a taxpayer. And if I may just point out, it comes down to what do we really prefer? Which form do we think is preferable in terms of due process? And I think the answer is in person. Anything less is not as effective. Now, it may be effective enough in a number of situations, but in terms of the most fair, in person would be the better default position. And my support for this comes from the board itself. Yesterday, I appeared before you, and we had several board members who remarked, boy, we should be in person. It'd be nice to be back in person. And I think you remember those comments. We had a technical glitch when the maps displaying the redrawn districts couldn't be pulled up. That's not a problem in an in-person hearing. At one point, Ms. Fleming's screen froze, and she was frozen out of the proceedings for a time. Even the link today for this meeting had to be changed because of a technical difficulty. So any move that excludes the right of a taxpayer to an in-person hearing limits him from obtaining what I think we all would agree is the most effective forum. So that's why we're putting all of this effort onto this language that the taxpayer should be able to initially designate the forum.
Good. This is Scott Donald.
Thank you, Mr. Ayub.
Appreciate it. Thank you.
I had one commentary, if I may. Scott Donald with Marvin Poor and Company.
Yes, go ahead, Scott.
Thank you. One is, while everyone was discussing this, I'm a very simple person, so I just went to Google and I typed in 2 words: participant, thesaurus. Participant. The first word that showed up was contributor. The second word was party. The third word was member. I don't see participant being anything other than a redress of the word party, and therefore I believe that the word should remain as taxpayer. I am in full support of virtual hearings. I utilize them significantly. I have not requested it in person, but we do have a few hearings at my level, the type of properties I handle, that we will need in-person hearings, not to the level of the 2 gentlemen here, Mr. Ayub and Mr. O'Neill, but we do have them. And we need to be afforded those rights for our taxpayers. But participant in Google search is the same word as party. And that's all I have to say. Thank you.
I appreciate that. Thank you. I see a hand up.
Yeah, can I just make
see
a comment?
a couple of hold on, there's a couple of hands I want to acknowledge. I see Leslie Morgan, I see Ms. Berkman, and
Ms. Gonzalez.
I got another hand. I don't even know who this is. So I'm going to go.
Ms. Cohen, how about Ms. Cohen, this is Ms. Taylor. Let me read the list of who has their hand up.
Okay.
We have Ms. Kasparian, Ms. Gonzalez, Ms. Berkman, Ms. Morgan, Ms. Moore, and Member Gaines.
Okay. So first, just out of deference, I'm going to go to hear from Member Gaines. Then we'll go to Ms. Morgan and
Great, thank you. I guess I want to make sure that the interests of taxpayers are protected. And I just philosophically believe that that taxpayer ought to have the right to make a decision as to whether they want a remote hearing or not. If the taxpayer is manipulating the system to delay, obviously we need to have some sort of mechanism in place to prevent that from happening. But ultimately, bottom line, I just think that that taxpayer should have that right on which way to present. And so I just want to clarify that's because I think that's, at least to me, is kind of core in terms of the ability to present a case, because the assumption is that the assessor is correct on the valuation, right? So you've got to prove that the assessor is inaccurate on the valuation of that particular property. Thank you.
All right, thank you. Next, Ms. Morgan.
What you were just speaking to is exactly why I raised my hand. There's so many cases, especially, and again, I'll speak to Shasta County. Most of the time, most of the cases we end up presenting are on owner-occupied single-family residences. And the burden of proof isn't always on the taxpayer. There's many cases where the burden of proof is on the assessor. So I just wanted to point that out because it felt like this conversation was going in a way where that was being lost in it. And again, just to point out that, you know, we are all looking for the most fair and efficient way, but there's times where, you know, we had Calaveras County almost lose their office one time in a fire. There can be other extenuating circumstances when we go back to what brought this out in the first place. You know, there can be situations where the assessor is the one saying, you know, we're going to need remote hearings. The only way we can address this workload, this burden, this set of cases is if we're able to set up a remote facility, whether it's lack of space, managing staff. And so again, I just want to put that out there in a way to get back to the point of the counties, the agencies, everybody whose first and foremost interest is how we fairly assess taxpayers. That's all of our goal here. But there is a realm here where the Assessment Appeals Board is administering how we come together and present our cases. And as an assessor, I want to be able to protect if there's a county office that needs to put in a request for whatever reason. I really don't see that happening all that often, but I want to be mindful that there are many cases where it is the burden of the proof of the assessor's office, and many times where, you know, we can see in this world we're living in now where there could be scenarios where it is the assessor who might then want to present a preference as to how a case is submitted. And I just don't want that to get lost in the conversation. So thank you.
All right. So I'm going to go to Ms. Berkman.
Thank you very much. As Ms. Morgan said, for example, in Santa Clara County, where I was board counsel for more than a decade, more than 95 to 99% of our cases were cases in which the assessor had the burden of proof and the burden of going first. I understand Mr. Ayub works on very sophisticated cases, so his personal experience may be different. But as someone who sat through every single AAB hearing and every single hearing officer hearing for more than a decade, it was the rare occasion when we had a case where the taxpayer had the burden of going first. As far as going back toward whether the word used is taxpayer or party or participant, the one thing the dictionary doesn't define a participant or a party as is a taxpayer. By virtue of the way the process works, the board, the AAB, is the neutral third party. Both the taxpayer and the assessor are parties before us. Under the Constitution, they have equal due process rights. Mr. Ayub has suggested that the taxpayer should be able to control the agenda where the taxpayer and the assessor disagree in terms of whether the format is remote or whether the format is in person. But it needs to be the Assessment Appeals Board and their clerks who ultimately make that decision where there's disagreement, because the parties are entitled equally to due process rights. Where they can't agree on the way things should go, it needs to be the Appeals Board and its clerks who ultimately are in charge of deciding that. They always try to accommodate both parties as due process requires, but ultimately the board is charged with being the neutral third party that puts on a due process hearing. Thank you.
All right, thank you. I'm going to ask Mr. Richard Moon to speak to Ms. Berkman's comments.
Richard Moon again with the legal department. I would largely agree with comments, and in particular, again, because this paragraph is about participants, and it's entitled "Rights of Hearing Participants," and using the word participant would include the taxpayer as well.
All right, thank you. Next speaker, I'm just going to go down the list. Ms. Kathleen McClellan.
Yes, thank you. I wanted to mention that, or just bring to light that something that CATA mentioned in their letter regarding remote hearings and what motivates us, the counties that are still having remote hearings and what the motivation is. And I'm not so sure that motivation is the correct term for this, because in the previous sentence prior to the section about remote hearings, it says that it appears that a number of AABs returning to in-person hearing has increased as the impact of COVID-19 pandemic subsides. In Sacramento County's case, that is not the case. We are not open to in-person hearings and have not resumed in-person hearings. We have a current county health order that has us having Zoom only or remote only hearings. And so that is number one, as far as the motivations listed: safe environment or public health concerns. That is the reason that we're doing this. And it's not a matter of motivation. It's just, it is what it is with the COVID pandemic. I don't think anyone has expected it to go on this long. And then number three listed as the remote hearing, our motivation is the remote hearing as a default option. The remote hearings being a default option is
Ms. McClellan.
Yes, ma'am.
I think we addressed this matter by allowing taxpayers to waive their 2-year statute of limitations to wait for an in-person hearing. I think we've already addressed that.
Okay.
All right. Thank you. I've got my colleague who's got his hand up, so I want to recognize Vice Chair Schaefer.
Thank you, Chair Cohen. Could we get an update to the board and to our constituents who are listening as to how many counties have gone back to in-person appeals board hearings and how many are still doing only remote? Or are there some that are doing both?
That is a good question. I don't know the answer. I don't know if Ms. Fleming or any staff member would be able to answer Mr. Schaefer's question. Maybe we can do a poll of those that are present. So the question Mr. Schaefer is asking is, how many AABs are remote and how many are online? Is that right, Mr. Schaefer?
How many are, yes, that is right.
Madam, this is Chris O'Neill. We have looked at that. Our understanding is that Los Angeles County, City and County of San Francisco, Ventura County, San Mateo County, and it was hard to determine, but now from their website, but it appears Sacramento County remain remote or virtual hearing only. My understanding is that other counties, that would be 53 counties in the state, which would include a lot of small counties which don't have assessment appeals boards, but use the Board of Supervisors, are currently meeting in person. I do know the vast majority of Southern California counties, with the exception of Ventura, are all back to in person.
Okay.
And I believe we checked, Contra Costa is back to in person. Santa Clara is in person. So I'm aware of those counties are in person as well, metropolitan counties.
So, Mr. Shaver, I think that answers your question.
Yes.
Okay. Ms. Morgan, do you have any data on this particular question?
I don't have any data in front of me to grab up, but again, I would just go back to the reality that who's to say that in 4 or 5 years, just the life in general hasn't changed enough that you find more counties wanting to implement remote hearing as an option or to incorporate it for their efficiencies for no other reason than just having it available.
Okay. So I want to go back to the issue that we were talking about earlier that's before us. I still have a few hands that I need to address. Ms. Gonzalez?
Yes, thank you, Chair. I think that I just want to echo what my colleagues have been saying, representing CACEO, that by using the term taxpayer, we are basically prioritizing the taxpayer over the assessor's office. And in our county, specifically in Sonoma County, we have been plagued with fires and floods, and of course the pandemic, as many other, all other counties have been affected by COVID. The purpose of this LTA was, or when it was originally written, was because of COVID. We don't know, just as Ms. Morgan was stating, we don't know where we're going to be 4 or 5 years from now. We don't know where we're actually going to be 4 or 5 weeks from now. And if this sentence is going to stay, I think that both the assessor's office and the taxpayer have equal rights. That due process should be afforded to both of them. We don't know what this summer is going to bring. May bring another fire. Our whole county administration building was evacuated for over 3 weeks, and our emergency operations center was activated. So we just don't know where we're going to be, and it really takes away the right of the AAB clerk to control their own calendar. And I think that controlling our own calendar is incredibly important. Thank you.
Okay, Mr. Parker, Mr. Thomas Parker.
Thank you, Madam Chair and members of the board. First, I just want to touch on a number of quick points here. First, as Ms. Gonzalez said just a second ago, the COVID impacts everybody, the AAB staff, the assessor staff, taxpayers and their representatives. COVID is not selective in the impacts that it hits all the participants in AAB hearings with. Secondly, raised letters, single family residences that are occupied by the applicant homeowners. The burden of proof is on the assessor. And if you look at the sheer number of appeals, whether you're a small county or a big county, there's a massive number of appeals by single family residence properties where the burden of proof is not on the taxpayer, it's on the assessor. It is also very easy and very common. Understand what the burden of proof is. The burden of proof is basically who goes first, who presents any kind of credible evidence for their opinion of value. That doesn't mean it's going to win the day in the end, but it's just some scintilla of evidence that could be credible and could be determinative. Once the side that has to go first presents that scintilla of evidence, that little bit of credible evidence, then the burden of proof goes away. And whoever is going to prevail in the hearing is based on the preponderance of the evidence, of all of the evidence presented at the hearing. The taxpayer is not at any greater disadvantage than the assessor once that initial scintilla of evidence is presented. Lastly, I would say we concur, I concur, and the CACEO concurs with the other county representative points that have been raised. Thank you very much.
All right. Ms. Alina Kasparian.
Thank you. For the purposes of, remaining brief and not repeating what some of my colleagues mentioned, I do want to say we concur with Berkman's initial suggestion or comment about the language change. I do understand the points that were raised by many of the CADA members. I do want to point out something that hasn't necessarily been brought out, and one of the main concerns with regards to the language of having party, Ms. Morgan briefly kind of touched upon, is some of the things that we faced with as an AAB. Very rarely have we received, a request for a platform that's one for taxpayer and an assessor opposing that platform. It's almost always been at the taxpayer or tax agent's request, and the assessor hasn't really rejected that. There have been instances, though, due to COVID impact, where our assessors, in an effort to resolve as many appeals as they can, and we're trying to streamline a lot of the efforts, they've added additional staff and resources, and many of that relies on the remote platform. So there have been and can have additional scenarios where we would be faced with a challenging situation where a taxpayer requests one thing, and the assessor, due to limited staff being out of the office due to COVID, but they're okay enough to, let's say, continue the hearing had they been remote. So those are the kinds of realistic scenarios that we're trying to consider with this, language change. And again, as many stated, a lot of companies have given up their current way of doing business and have release some of the leases they have and are 100% remote, and that's the future for them. Who knows what's to come? Of course, we plan to have a hybrid solution in LA County, both in person and remote, but we just think that it is essential to consider the assessor as well in this equation, and ultimately for the AAB to be the deciding factor if there is a disagreement in the choice of platform. Thank you so much.
Okay, thank you. Mr. Ayub?
Thank you, Madam Chair. A couple of things, since I was the point of one of the comments. I go back to my original point. Which forum provides the most due process? And I think it's certainly the in-person. The only reason we find ourselves here is because of the COVID-19 problem, and we needed the system to keep going. And I think remote hearings, everybody agrees remote hearings are a useful tool. But I back to the point that I believe that the taxpayer has the right to get an in-person hearing if he wants it, and that should be the primary position. I make a couple of points. As the chair pointed out, all of these issues about calendar control and delay in getting a hearing and being able to do it appropriately when someone requests an in-person hearing, and all of the COVID issues affecting staff at the assessors or the assessment appeals board offices, all of that is taken care of by the waiver provisions that have been put in. If you want that in-person hearing, you may be asked to sign a waiver, and that protects all of the concerns that the clerks have raised. We got sidetracked on this burden of proof thing, and that's not the key issue. The key issue, as Board Member Gaines pointed out, is the taxpayer initiates the action. The taxpayer pays the tax. And if he has a delay, his tax is still sitting out there, not refunded until his appeal is resolved. I've had taxpayers who are waiting 5 and 6 years to get their appeals resolved, but they're willing to wait so they can have that day in court. And so to deny them that day in court, if that's where they want to be, and by their own choice are willing to take a delay in the refund of the tax that they paid, they don't get any prepayment remedy, they have to wait for that appeal to be done. The taxpayer's at the disadvantage. Think of it the other way. If the assessor wanted to delay the taxpayer from getting a timely hearing, they could do that. The taxpayer has to have the initial right. After that, you know, there are those abilities that we have in the letter, and I think those are all appropriate. But that initial point of changing taxpayer to parties, who gets to make the choice in the first instance, I believe, has to remain with the taxpayer. They're the ones that initiate the whole process. They're the ones that pay the taxes. We all, everyone on this call, works for the taxpayer, government and consultant and attorney alike. They should have the choice. Thank you.
Thank you. I want to recognize our last hand is Ms. Marcy Berkman. Ms. Berkman, are you ready to speak?
I'm sorry, I forgot to turn my microphone on.
Okay.
My proposal to change one word to participant seems to have initiated a very long and saddening and disheartening discussion. And perhaps some people don't happen to have the LTA draft in front of them. The vast majority of the draft in this section uses the word participants. The draft, and no one disputes it, everyone was in consensus, says in sentence 3 that participants can reject a remote hearing, yada, yada. The only suggestion I was making was to sentence 2, which was an introductory sentence, in which, as what appeared to be a clerical not consistency with the rest of it, used the word taxpayers when the next sentence talks about participants. So I was suggesting what appeared to me to be a very common sense clerical change to the word participants, since this whole paragraph is the right about hearing participants. And since we have all long been in consensus about the right of either participant to request a change in the hearing format, and all in consensus on the 120 days. So I've been very disappointed to hear this conversation devolve into what almost sounds like people want to backtrack from that. The change that I was suggesting in sentence 2 doesn't change sentence 3 and the rest of the paragraph. It was just designed to make it linguistically consistent with it, and I was simply pointing out that constitutionally that makes sense as well, as recognized in sentence 3 and all of that. And on a humorous note, no, we're not all being paid by the taxpayers. I am retired. I'm not being paid by anyone.
Okay, I just seen that our hand popped up, Mr. Ayub.
Yeah, just to briefly respond, Madam Chair, thank you. It's important to understand the structure, of this provision. The first portion is who initiates the request of forum choice. It's the taxpayer. Then if the taxpayer requests a remote hearing, any participant can reject the remote hearing and require an in-person hearing. I believe that's the way that proceeds. So again, I return to the whole, focus is the taxpayer initiates it. They should have the choice of forum, just like you do in court when you pick your district that you want to bring your court case in, whatever. The applicant, the taxpayer, should have that choice. And then the rest of the participants can ensure due process through the other various provisions, insisting on waivers, whatever it may be.
All right,
control the calendar.
Excuse me, I'm sorry, Mr. Ayub, I thought you were done. So what I'd like to do is I want to respectfully point out that the Board of Equalization Counsel, Mr. Moon, has opined that the legislature has authorized remote hearings, pandemic or no pandemic. I also want to point out that we address the taxpayer's ability to waive their 2-year statute of limitations to wait for an in-person interview. And I just want to make sure that we all remain mindful of this. Next, before we proceed to the next issue, I want to ask if any of my board member colleagues, if they have any additional comments or questions. And I see Ms. Stowers, I see your hand. I'll acknowledge you first. Thank you.
Thank you, Chair Cohen. Very interesting conversation. I respect the positions taken by all of the participants of this work group. I believe that that paragraph is talking about participants is clearer when it has the rights of the hearing rights of the participants. And participants includes the taxpayer, obviously, and of course they come first, but participants also includes the assessors. I like the comment that Member Gaines made of why not define participants. We were to, as a motion as a board, move to insert the word participant as opposed to taxpayer, and also direct BOE staff through the executive director to define participants. I think we may not have a complete agreement with all of the participants of this work group, but we will have clear guidance as it relates to the issue at hand. Thank you.
So is that a motion?
That's a motion.
Can you restate it a little more succinctly? Because I thought I heard motion, but I wasn't.
You heard a motion. I was rambling, and let's see. I move that in the paragraph defined as rights of hearing participants, we strike out the word taxpayers and insert participants, starting at as an initial matter. This includes participants. I also move that we direct the executive director and her staff to define participants within this LTA.
I second that.
Okay, so we've got a motion made and a second by Vice Schaefer. I want to acknowledge, well, actually, first, before let me bring in Richard Moon to speak to the motion real quick. Mr. Moon, can you opine on this motion? And then I'm going to pivot to Board Member Vasquez.
Yeah. Yeah, I mean, I guess the only thing that I would say is if the board moves and that's accepted, I mean, we'd be happy to draft language and put in definition of participant for the board's consideration.
But then you haven't defined.
Okay, somebody needs to mute themselves. I'm sorry, Mr. Moon. I hear. Oh, Mr. Ayub, I think you might be. No, I don't know. Okay. My apologies. All right, Mr. Moon, please continue.
I was just saying that if the board so moves, we'd be happy to add a definition of participant for your consideration.
All right, thank you. Mr. Vasquez and then Mr. Senator Gaines.
Actually, Mr. Moon, if you're still there, that was going to be my question. Does your definition of participant include the taxpayer and the assessors?
Yes, I mean, we'd have to think about exactly what words we would want to use to define it, but certainly any definition would include those parties.
Thank you.
Mr. Gaines.
Okay, great, thank you. I did want to speak to someone from CADA and just get clarification on this motion as to whether this helps resolve, from a clarity standpoint, the issues that you've raised. I don't know if that would be Mr. Ayub.
I'll respond, Senator Gaines, if I might. It needs to be thought of in 2 or 3 steps here. If any participant can designate the forum, either taxpayer or initiate the designation of the forum, either the taxpayer or the assessor. And as a general matter, not as an absolute matter, you can reject a remote hearing. There are going to be situations where the taxpayer will want an in-person hearing and can be denied that. So either the taxpayer has to have the right to initiate the forum choice and elect an in-person hearing, or has to have the absolute right to reject a remote hearing if the assessors request a remote hearing. Otherwise, you will have the situation, it could happen. I'm not saying anybody's going to act in bad faith, but there can be a situation if the taxpayer can't choose in the initial instance and doesn't have the absolute right, it's only as a general matter, but if he doesn't have the absolute right to reject a remote hearing, he can be denied an in-person hearing. Now, I'm telling you right now, we've conducted a number of in-person remote hearings. We've conducted hearings for single-family residences. It's a useful tool. But again, I go back to this board yesterday, the difficulties we were all having in the remote situation. Now think of a 10-day hearing with 50 or 60 exhibits, witnesses, cross-examination, etc. I don't think we should be drafting a document that allows a taxpayer to be denied an in-person hearing if he so elects. That's the problem with these two sentences together. That's why it's taxpayers in the first sentence and then participants in the second section. I understand that there's this desire to be consistent between participants all the way through, but they serve different purposes. Who initiates the request, then what do the other parties react to? So that's the reason why I don't think it works from CADA's perspective. I'll yield to Mr. O'Neill if I've missed anything, but I think that summarizes our position.
I agree with Mr. Ayub. That is consistent with CADA's position.
Thank you.
Okay, I'd like to ask a question then of the maker of the motion. Would you be willing to change the wording to provide clarity that the taxpayer would get to make the choice in terms of whether they're going to have a remote hearing or not? That seems to be the crux of the matter.
First of all, I do believe that taxpayers should have the choice. This just going to be me rambling for a minute. And I get, depending on the type of cases, whether it's any kind of case, taxpayers would prefer to be in person. And it's been my understanding, and they've said over and over again, that the clerks will accommodate that request. If they want in person, they will accommodate it. Here's why I'm having a problem to say let the taxpayer decide first. I believe the clerks have constantly said that they have control over their calendar. And I think there's a difference in opinion between that with CADA and the clerks. If I hear what CADA is saying, no, the taxpayer has the ability, or they should have the ability to say, I want an in-person hearing.
Yeah.
And I get they should have the ability to say that, but the clerk, the first step should be on the clerks scheduling whichever hearing they schedule, and then the taxpayer saying, thank you, but I prefer an in-person hearing.
Okay, so here's my issue is that if you have a county that's backlogged on their hearings, how are you going to get due process for the taxpayer? You know, if you give that authority to the assessor to make that determination on whether it's a remote hearing or not, and you have a 2-year backlog, isn't the taxpayer always going to lose in the sense that they're not going to be able to decide how to present their case?
I don't think so. I'm not giving it to this, as I'm saying participants, whatever the language was in the motion, the participants' rights to meet either remotely or in person. And participants do include taxpayers and assessors. But I'm saying at the initial start of it is going to be the clerk who's doing the scheduling of the case, and the clerk is going to initially put out either an in-person or a remote hearing. And then at that time, the participant will say, I prefer to have a remote hearing. And ever since we've been in this COVID-19, participants named taxpayers have been having the ability to go with a remote hearing, whether it's in the property tax form, sales tax form, all you guys practice in all these arenas, sales tax, office of tax appeal, and the franchise tax board special regulations. So the taxpayers have always been given an opportunity and will continue, I believe, to say, I want in person and I will wait. The only difference is in the property tax rules, that is that 2-year statute that a decision has to be made on a case. So that's the problem that we have in this arena. But
so could we amend
I know I'm rambling, but.
So would you be open to amending the motion to clarify that the taxpayer has the right to make that decision? That's, if I could have that clarity, I'm supportive.
Okay, let me see if I can get some clarity. So Ms. Stowers, I believe that we've heard both. I do have one question for the work group participants. Currently, if a taxpayer chooses a hearing type, remote versus in-person, is there ever a situation when the taxpayer's preference is not honored, believing the taxpayer waives the statute of limitations?
Just say, excuse me, Ms.
Point of order, Madam Chair. Vice Chair Schaefer, I withdraw my second. I was deferring to the superior experience of.
Okay, got it. You're okay. We know that your second is withdrawn. Okay, but my question is that, and maybe it's directed to more the advocates. If a taxpayer chooses a hearing type, has there ever been a situation where their preference wasn't or hasn't been honored? Edward Yin.
Thank you, Madam Cohen, Chair Cohen. I guess I'll try to answer your question, but then also just address something that Mr. Ayub had suggested before. So we haven't had an instance in LA County, that is, that we rejected the taxpayer's request. And right now, based on our statistics, most, if not all, but many, and I think Ms. Alina Kasparian had suggested that we had probably around 98% remote hearings move forward, only 2% have really requested in person, and of the 2%, 90% are from represented taxpayers. So they're usually tax agents are requesting it. So we have not had instances where we have that conflict yet. Now, I do want to address real quickly what Mr. Ayub was suggesting, that if taxpayers are requesting an in-person and that the assessor would object to that based on complexity, because of the case is really complex and they want to be in person. What happens if it gets flipped around and it's the assessor who is now requesting a in-person because they believe that the complexity of the case requires an in-person, but the taxpayer now does not want to be, they want to be remote. So then that instance, that's where we have a third party, which is the Assessment Appeals Board, to make that decision based on various circumstances. We have the 2-year statute of limitations, we have accessibility, we have staffing, we have Assessment Appeals Board member availability. We have all of those that we have to consider when making a decision on calendaring those assessment appeals. It's not just going to be on the determination of what the taxpayer or the assessor wants. And that is the key to and the crux to what we're trying to do in this LTA, is to ensure that as the Assessment Appeals Board, that we have the right and we have the duty to ensure that we have a fair and equitable, impartial Assessment Appeals Board who evaluates both the taxpayer as well as the assessor's positions on that appeal.
And Mr. Yin, who do you represent?
Sorry, I represent Los Angeles County. I'm the Assistant Executive Officer, and of one of the many areas I oversee is the Assessment Appeals Board. Many of you may know me from my previous iteration. I was also working for the Assessor's Office, although I've now changed hats and I'm purely Team Assessment Appeals Board.
Got it. Thank you. All right, I've got Mr. Thomas Parker, and then we've got Mr. Thomas Parker, and then we've got Miss Ann Moore.
Thank you, Madam Chair. Some of this debate, as I've been following it, seems to imply, although no one has been willing to come out and say it so boldly as I will, a lack of trust in the willingness and the ability of the AABs, wherever the AAB is located in this state, to make a fair and reasonable decision and not go out of its way to favor assessors. The very implicit underlying tone to some degree seems to be that AABs will favor assessors. And one could debate why that is, but I just have this feeling that it's there. And what I want the board to understand is, not just in LA where I happen to work, but in all the other 4 counties where I worked that were smaller, the AABs did not favor assessors, and they did not make decisions because they liked the assessor more than taxpayers. I would ask that the state board give a degree of trust to AAB so that when we tell you in all sincerity that we need to control our calendar as an impartial hearing body, we mean what we say. We are not anti-taxpayer. We are not pro-assessor. We're going to hear all of the evidence. Everyone is going to get to submit the evidence they want to submit to make their case, and somebody is going to win by a preponderance of the evidence. But we can be trusted. We're not anti-taxpayer. Thank you.
Thank you for the clarification. Ann Moore?
Hi. I can say from San Diego County's perspective, we only had about, when we were closed and virtual only, we are open now, we only had about 10 people insist upon in-person hearings of the thousands of hearings we heard. We, of course, had to defer them until we were able to have in-person hearings. So I think that is the situation that most people will find them in, is not that they're being denied their hearing type, but that it's being deferred until we're able to offer that. I also, know that there are some counties that aren't able to offer virtual at all. So if the applicant wants virtual because of health reasons or anything along those lines, there are counties that either because of staffing reasons or technology reasons can't offer their preferred hearing platform. And I can say that from our perspective, we are trying to honor all requests for virtual right now for that reason, because we recognize that the pandemic has continued to be difficult for certain populations who may have compromised immune systems, and we want to offer the ability for parties to be comfortable no matter what platform that they're using. But I did want to touch back to Mr. Gaines' point about backlog. The management of the different hearing types and trying to balance requests for each hearing types creates more backlog than simply just offering what we're able to offer given the current public health situation. The trying to juggle multiple calendars with COVID creates a need for us to create clerk's convenience backlog calendars that continue to grow. So I don't think that restricting only taxpayers to have the right to assert their preference for hearing is going to solve anything regarding backlog. Thank you.
Of course, thank you. All right, Mr. Ayub?
Thank you, Madam Chair. And I'm sorry to keep raising my hand, but I want to be sure, I put a fine point on the comments that are being made. And again, the perspective, even though they haven't had any problems yet, we haven't had any problems yet with remote or versus in-person hearings. We're planning a policy even though the issue hasn't come up yet, we're planning a policy that has to cover those situations. To the backlog issue, LA cleared 100,000 case backlog in the 90s without remote hearings. So, you know, we need to focus on whose rights we're affecting here. It's not a matter of trust. I don't trust anybody in government more than I trust Tom Parker. He's one of the most honorable guys I've ever met. It's not an issue of trust, but you have to ask yourself this question. If a taxpayer wants an in-person hearing and is willing to sign a waiver, should the policy be that he can be denied that in-person hearing? Right now, the way these two sentences read together, or would be read together if you change taxpayer to participant, a taxpayer could be denied an in-person hearing. That's all I'm saying. And I just don't think that should be the policy. Now granted, it may be 1 in 1,000, but that 1 in 1,000 doesn't get the forum that he believes affords the most due process.
Okay, Mr. Edward Yin.
Apologies for coming in again, but I just didn't want the last word to be that the Assessment Appeals Board would somehow take it upon itself to reject the opportunity based on this LTA to allow a taxpayer to have a form of their choice. And I think, you know, throughout this process, you know, the LTA is very clear that, you know, if an extension is requested, you know, our Assessment Appeals Board would wait and grant the taxpayer the form that they want, whether it's virtual or in person, depending on the circumstances that are raised. You know, there may be a situation where the taxpayer wants remote, but our systems are down. You know, our board supervisors meeting yesterday had an issue with AT&T conference call line. So there are circumstances where technology may be down, and we would recommend an in-person if that is necessary. So I think I just want to make some clarification that, you know, I don't think this LTA would be setting a policy that would suggest that the Assessment Appeals Board would somehow reject the taxpayer's request. In fact, our Board of Supervisors are elected officials themselves, and all our departments, we hear the taxpayers and constituents, right? And those taxpayers' constituents, they will speak out, and we will hear them. And that is why it is our job as an Assessment Appeals Board to ensure that we have the best access that we can bring to the taxpayers. Thank you very much.
All right, thank you. I see no other names in the queue. So I want to pivot back to where my board members are. And there was a motion that was made, and then the second was made, and then it was repealed. So we still have an open motion on the table. I have actually also additional question for the work group members. So work group members, I'm being reminded by my team that that we drafted this language intentionally with the benefit of the taxpayer in mind due to the pandemic. If you take a look at the language, we even address the pandemic in the final line that no longer exists. I'm wondering if it's premature to make this change. Take a look. I'll give you a second.
Chairman Cohen?
I'm here. Yes.
While they take a look, and I realize I don't have a second on my motion at this time, but Member Gaines asked, would I be willing to make some modifications and with the focus more on the rights of the taxpayers.
Okay.
So I've been trying to play with the language, and this is what I've drafted. As an initial matter, this includes participants' rights to meet either remotely or in person.
Mm-hmm.
AAB boards are encouraged to accommodate a taxpayer's request to reschedule a different hearing type, remote to in-person or in-person to remote. I'm hoping that that addresses the concerns that the taxpayers' rights should come first.
Ms. Stowers, this is Ms. Taylor. Could you please repeat that?
Sure. As an initial matter, this includes a participant's right to meet either remotely or in person. AA assessment appeal boards are encouraged to accommodate a taxpayer's request to reschedule for a different hearing type, remote to in-person or in-person to remote.
Okay, I think you got people processing. I see your hand, which is a good thing. So let's pivot to Mr. Gaines. I see your hand up. Go ahead, sir.
I want to thank Member Stowers for her effort in trying to figure this out. I really appreciate it, and I would like I just like more certainty in that language. And I know that you're saying encourages, but I think that should be a requirement. So if we could put in the word is required versus encouraged, that solves the issue in my mind. I just am concerned that there be circumstances where the interests of the taxpayers or a taxpayer would not be represented in the best way of that particular individual because of the way the evidence had to be provided, whether it was remotely or in person. And I just defer to that taxpayer because the taxpayer is up against, you've got a situation where you're dealing with an entire agency, and I just want to make sure that the rights of that taxpayer are protected through the process. And I feel that as long as the process is not being abused by that taxpayer, that they ought to have that right to make that decision.
Hold on, Mr. Schaefer.
Yes.
Hold on. Go ahead, Ms. Stowers.
And I played with putting in are required or shall, but I think we might overstep if we put that in there. I would defer to Mr. Moon on if we could require the AAB boards to do something. I don't think we can. So that's why I didn't have it in there. But I strongly support taxpayers having the right to request a different type of hearing.
Yes. Okay. All right. So, yeah, we could hear from Mr. Moon, but I'd like to also hear.
Mr. O'Neill has his hand up too.
So.
Okay, so hold on. We're going to hear from Mr. Moon, then we'll hear from Mr. O'Neill.
Ms. Stowers and Mr. Gaines. So I don't believe the LTA, if it were the board's desire to institute some type of requirement that the taxpayer have a choice, I don't believe the LTA would be the proper way to do that. I think the board would most likely have to do that through regulation or through statute.
Ms. Stowers, you're giggling.
Thank you. I don't mean. It's very important. I'm not giggling. It's just so ironic that I agree we would need a rule change. One reason why we went with the LTA in January 2021 because we saw the urgency and we wanted to get it done as quickly as possible. And a rule change would take what? A year? That's why I'm giggling. But thank you, Mr. Moon, for that clarification. So okay. I don't think I'm gonna get a second on the motion. I wish we could get somewhere on this issue, but maybe we go to rulemaking.
Okay, let's hear from Mr. O'Neill.
Thank you, Chair Cohen. I was going to say that Kata understands Member Gaines' comments. We do agree with Member Gaines that, and I guess maybe what indirectly Ms. Dowers is saying, and that is that unless there's some sort of language that's going to make this mandatory, that it's a requirement and not just it's encouraged, there will be those circumstances where a taxpayer who seeks a certain type of hearing will not get that hearing, either because an assessor asks for something else or because a board, because of a circumstance, says we just can't afford you that kind of hearing right now. So, but given that Member Stowers has withdrawn her motion, I'll just put that comment on the record and leave it at that.
All right, so we've had a really, I think, robust discussion for the last hour and a half. I want to ask all the work group members to consider this issue until the next meeting. How do you feel about that? I see a yes from Mr. Ayub. Colleagues, Mr. Donald Scott is saying yes. I can't see my folks on the phone. Maybe you guys can raise your hand, Ms. Berkman. Who else is on the Ms. Kasparian? You know, so Ms. Morgan, Ms. Leslie Morgan. So Yvette, I want to just, Ms. Stowers, I want to just acknowledge, I appreciate your efforts, and I do find the irony funny as well. And I applaud the good college try. But I don't know. I mean, if parties are interested in keep going, or shall we table this for next month and really work on trying to get some resolution around this? If there are any other consensus items others want to raise, I'm happy to take them up now.
Madam Chair, just yes. To be clear,
sorry, non-consensus items. Go ahead.
Okay, on consensus items, just to be clear where we now stand, this is Chris O'Neill with CATA. The board has adopted the draft as issued last week by Mr. Young and his staff. And if I understand correctly, the only issues that would be, if we carry this over and don't continue today, the only issues that we would be looking into is this word taxpayers on the fourth line of the middle paragraph on page 2. And I think as that ties to or relates to the words as a general matter. Is that the only issue that, Madam Chair, you and the board are still wishing to get some more input or clarity on?
No, because we still have all the non-consensus items. Remember when people were making their opening remarks, there's a couple of non-consensus items. This was just something I thought that we had a little bit more consensus on, so I thought we would start. But it's turned into a point where it's sticky. So, and then we need to address some of the things that were left over from November. So I don't want to get in the habit of kicking things down the can, where at some point we're going to have to make a difficult decision and keep moving forward. I'd like to pivot from this conversation and just table it till next month. But I do want to hear some of the non-consensus items that people were speaking to earlier when we were doing some of the opening remarks.
Okay, so, Madam Chair, since CATA on the agenda, since CATA was item C, so really the first one that came up, maybe I'll just jump in right now.
Okay.
The draft LTA that was issued last week by Mr. Young and his staff, we only had the concern about the as a general matter language that I'm aware of, which has now morphed into including the taxpayers wording. And I'm not aware of any other matters, because I guess maybe we have to hear from CACEO as to where they stand. Only other thing I'm aware of they've raised is inserting a recitation of California Constitution, Article 13, Section 16, which discusses an appeals board's power to enact rules of procedure and notice. And the language they have in their letter is difficult because it says enforce, and that's not correct. I'm not aware of anything else out there that we need to be addressing. So, however, CADA is willing to, have what we've done today put in a final form as adopted by the board earlier this morning, and then see what issue remains. I think it's only one, though, that I'm aware of, or perhaps two. That's all I have.
All right. That's a lot. Thank you. Let me see, colleagues, board members, anyone else have any thoughts to what Mr. O'Neill said?
Madam Chair, this is Thomas Parker from CACO.
Okay.
We are content for the moment to put aside the debate regarding participant versus taxpayer, but we did add some language, a language proposal, which we believed was consistent with the otherwise existing proposed language of rights regarding infeasibility in our January 25th, 2022 letter. We certainly hope and we certainly believe that the infeasibility language is not inconsistent with the language that the state board has put out there for public consideration and in fact approved on a motion however many minutes ago. But we do ask for consideration of this clarification or tightening language to improve the language further.
To improve the language further, okay. All right, thank you, Mr. Thomas Parker. Kate, any comments regarding the infeasibility language?
Yes.
By CACEA.
Yes. Thank you, Madam Chair. Chris O'Neill for CADA. I believe that sentence, unless it is infeasible for the appeals board to hold a timely hearing under the particular circumstances using the party's preferred type of hearing. I think the chair has already addressed that. You did so early this morning, early in the meeting, where we said because there's a waiver under section 1604 that's available. Because of that, I'm really not thinking that addition is necessary in this paragraph on page 2 of the draft LTA. I think it's covered by language further on down that says the taxpayer, the applicant can sign a waiver.
Okay. Awesome. Okay, let me see. Let me look at, I see Edward Yen's hand.
Yes, I think just kind of to add on what Mr. Parker is saying is that the reason why it's inconsistent is because throughout our entire discussion, these last 10, 15, maybe 20 minutes or so, we've been talking about the potential of, whether it's the assessor wanting something and then the taxpayer disagreeing or vice versa. And the language is just clarifying that if it's not possible to provide either one, whether it's the assessor or the taxpayer, their choice of forum, that we as the Assessment Appeals Board have to make that decision for them. And so that, that is to cover the potential circumstance that may come up. And I think that's why we feel that if we insert that in that same paragraph after the language in that paragraph with let's say after as an initial matter, and then includes the taxpayer's right to meet either remotely or in person. In conjunction with that sentence, what it helps clarify is that although we will try to meet either party's preferred mode, that if it's infeasible, if it's not possible because of whatever the circumstances, that we will then have we'll have to choose, or then what you can do is the suggested language that Mr. O'Neill has stated. You could sign the waiver and we could extend that until we could get your choice of forum for you.
Okay. One more hand.
Madam Chair,
hold on, Mr. O'Neill. We got to go in order. Alina Kasparian.
Just a quick comment. I just want to remind everyone that waivers are, you can terminate a waiver at any time. I know that's the obvious, but we tend to forget. So that can happen, and that's not the ultimate goal for the AAB, hence the backlog that's been growing, for decades in LA County, which consistently happens on vacating our agendas, which was kind of the initial reason for our involvement in this LTA, was to facilitate our agendas better. So it's not just a waiver. I do want to emphasize that.
Okay.
Thank you.
Okay, I appreciate that. Mr. O'Neill.
Thank you, Madam Chair. The point that Mr. Yen raised is really the point that we've been discussing for the past 90 minutes. I think that sentence or that clause rolls into this whole concept of, does the taxpayer get to choose first? What if that choice is countered by the assessor or by an assessment appeals board clerk? I think we roll that issue into the discussion next month, the issue that Mr. Parker raised and Mr. Yen has discussed.
Okay. Okay. Mr. Parker. Mr. Parker, I'm wondering if you have a counter response.
Yes, Madam Chair and members of the board. We don't believe that the proposal that we've made, nor the riff on the proposal that Mr. Yen raised a moment ago, is inconsistent with the language of the LTA.
Okay.
So we don't necessarily see the need to prolong the discussion on that point, but it is up to the state board, obviously.
All right, colleagues, just really quick, I just want to do a time check and a bio check. We're approaching 12:30. Wanted to see if we should take a lunch break or continue to conclusion. I vote for a lunch break. I'm talking to my elected colleagues here.
How much longer do you think we have to go? I thought we could wrap it up. If not, if you think it's going to take longer, I would say take a break.
Okay. I don't think it would take, I do not think it would take longer, but again, I wanted to check in. Ted Gaines, do you have any feelings on anything, one way or the other?
My thought is if people need a little break, that'd be okay. If they need to.
Okay, that's fair enough. Because we have also staff, the transcriptionists. We've got other people that we have to take into consideration when making this decision. So let's go ahead and take a 10-minute break at this point. It's 12:23. We're just going to recess for 10 minutes. Let's keep it tight so we can get back and not lose this momentum. All right, folks? Thank you.
Thank you, Madam Chair.
Hold on. All right, everyone, I thank you. I trust that short break was beneficial. I have concluded that based on the discussion on the last issue, that we are at a non-consensus, and that we are at a non-consensus point, and that the work group participants are there. And to the work group participants, are there any outstanding non-consensus items that the work group would like to present or would like to discuss? All right, I see a hand. Ms. Leslie Morgan.
I guess I have a question about the point at which we are and the moving forward. I know that the opinion of Richard Moon had to do more with the board's authority to even put in language, such as was being suggested. So I guess that's part of my question in terms of what the next meeting is going to be about. Is it going to be about getting an LTA to the point of being presented to assessors and appeals boards with the generalized oversight in which the board's role is? Or is it to hold off on this LTA and attempt to get consensus? Because I'm a little bit confused on where those boundaries are right now, because I think that anything that's non-consensus right now really is about how much authority the board even has in the issue of being able to put the language being suggested. So I guess that's either a question that can be answered in the next meeting, but in general, I was just curious, is the goal, I'm assuming the goal is still to get an LTA out with more clarifying language on these consensus items.
That's right. That is the goal. Ms. Morgan, as you are aware, we approved the LTA, and the executive director will finalize and issue it.
Madam Chair, may I speak? It's Chris O'Neill with CADA.
Yes, please. I didn't see your hand. Please speak.
The CADA is prepared to accept the draft LTA as adopted by the board and as written in that paragraph on the middle of page 2, as is, with the word taxpayers and with the words as a general matter in the following sentence. CADA has no other issues, non-consensus issues to raise with regard to the draft LTA as presented last week and as adopted by the board this morning.
Okay. Thank you, Mr. O'Neill. I appreciate that. Ms. Morgan, also just wanted to let you know in terms of as to going forward, I just want you to be aware that there is a county that would like to make a presentation to the work group about lessons learned related to remote hearings. So that, I think that speaks to the immediate question of as to what are we going to be doing? If we meet again, what are we going to be hearing? And so I'd like to give that county an opportunity to make the presentation. And it's about a 15 to 20 minute presentation with some salient and interesting points and lessons learned that I think that would benefit the entire work group.
Thank you.
No, yes, no problem. No problem. So that will be the focus of the next convening. All right, so let me see. Let me go back to Ms. Taylor. Ms. Taylor, I was wondering if there's any public comment that we need to take.
You know, it's probably a good idea to ask for public comment because we're still on sub-item D, and then we can move on. So if you agree, I will do that.
Oh, yes, I agree.
Thank you. AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Okay, ladies and gentlemen, if you'd like to make public comment, please press 1, then 0 at this time. 1, 0. And
Let me check to see if there's a technical difficulty since we've not heard from AT&T. Is there someone on the public line?
This is Ryan with AT&T. Can you hear me?
We can now.
Okay. Once again, if you'd like to make public comment, please press 1, then 0. We have no one in queue at this time.
All right. Chair Cohen, would you like me to move on to the next sub-item? Our next sub-item is F, follow-up on other key issues needing additional guidance regarding the remote AAB hearings. As noted previously, all work group members may participate in this discussion. Speakers on sub-item F include Thomas Parker, Honorable Ernest J. Dronenberg, Mark Aprea, Richard Ayub, Chris O'Neill, Scott Donald, and David Young. Chair Cohen, you're muted.
Thank you. Speakers, are you guys all ready to present? All right,
Madam
sounds
Chair,
good. Yes.
Parker.
Yes.
Members of the board, I apologize for delay. I know this has been a long day for everyone. I'm trying to get some quick guidance from the association on item F as to whether there are other key issues that need additional guidance at this time. So if beg the patience of the board for a minute or two, hopefully I can get some guidance, please.
Sure, no problem. Actually, we could go to the next speaker.
Thank you.
And that next speaker is, I've got on the agenda, it says Mr. Ernest Dronenberg, but I'm sure Leslie Morgan might want to step in.
Yes, sorry, I was typing as well as listening. So, but yeah, I don't know that there's anything much more to add other than in transitioning and here in Shasta County, you know, like for us, in person is the way we do it day in, day out. And I assume that most counties are in the mindset of that's generally preferred. But in terms of the transition, I do think we all need to be mindful that the transition of the future is more likely to include remote as an everyday practice. So.
Okay, thank you for that reminder. Does that conclude all your remarks?
Yes, thank you.
Okay, so I don't know if Brianne Rabowski is back with us. Is anyone speaking on her behalf? No one from, is there anyone from CADA? No? Okay, we'll skip her. Then we'll go to Mr. Mark Aprea.
Madam Chair, yeah, I just want to say that as a letter to you last week indicated, Mr. on maternity leave, and that as a result, Mr. Neal, AU.
I'm sorry, I don't know if anyone else is having trouble. We're having trouble hearing you. Could you speak up a little bit?
Yes, so this is Mark Aprea. I am. Yes. I just wanted to let you and the other board members know that Brianne Rabowski is on maternity leave, and as our letter reflected, Scott Donald, Chris O'Neill, and Richard Ayub are here to represent CADA, and consistent with our comments in November, it takes 3 men to replace 1 woman. So for the foreseeable future, these 3 gentlemen will be representing CADA on the working group meetings.
Okay, wonderful. All right, well, let's see if Mr. Kevin Moore has anything to say.
He will not be participating, Madam Chair.
Okay. Bradley Marsh?
The same.
He will not be participating either.
Okay, and what about David Young?
Yes, thank you very much for the opportunity. No, there are no other additional items that I wish to address at this point. We've had a very, very vigorous discussion already on it. If it pleases the board, can I bring something back up?
Yes.
Mr. O'Neill made a comment on the previous item on D, that they were able to, they're okay with moving forward with the letter as edited by staff. And that leaves in the portion about the taxpayer, that leaves that in, but it also leaves in the portion with as a general matter. If we can, are the clerks okay with that, or does that still need to be brought back up next month?
I feel like the board already approved the letter.
They did. They did as approved. But if that is no longer an item of contention for CADA, I'm asking, is it still an item of contention for the clerks?
I think it's a non-issue. I believe it's not I don't want to speak for them, but let me see if I don't see any hands up. I don't see any hands up, so I'm going to take that as no, it's not an issue, Mr. Young.
Okay. I'm sorry. I believe Mr. Parker was going to. He's been conferring with us offline, so I believe he's going to mention something about our consensus.
Right, because your letter of January 25th has language in there you wish to, one, replace and two, insert. So if that's no longer an issue, then perhaps we can have one less issue.
Okay. Let me check in with a few of the other work group members. Mr. Ayub?
I'll defer to Mr. O'Neill. I think we're fine, to Mr. Young's point, we're fine with the letter as is, as long as it stays as is. If something switches with the as a general matter or with the taxpayers, then both those sentences are connected in a way. But the way it's set up right now, with the taxpayer and having that initial choice, I think it works.
Okay, Chris O'Neill, anything from you?
No, nothing, Madam Chair. It is CADA's position that second and that third sentence are linked, and so that's why taxpayers' right and as a general matter are both in there. If they're both in there, CADA stands on what the board has adopted today, and we're fine with it.
Okay, so I just want to make sure I'm clear. I'm not actually discussing the letter. It's no longer up for discussion. I'm actually I'm referring to outstanding matters.
There are no other outstanding matters that CADA wishes to raise with regard to this proposed or draft LTA as adopted today by the board.
Okay, I apologize if I wasn't clear about that. All right, so seeing that there.
Madam Chair, this is Thomas Parker. I've gotten consensus of the Clerks Association.
All right.
Guys, it took a little longer than I hoped it would. We have no non-consensus issues, and we accept the LTA as it has been submitted to the public and also as approved by your board by motion.
All right, thank you. I appreciate that. So let's go to public comment. Seeing that I had no hands up from my colleague.
All right, AT&T moderator, please let us know if there is anyone on the line who would like to make a public comment regarding this matter.
Okay, ladies and gentlemen, if you'd like to make a comment, please press 1 then 0 at this time. 1 0. And we have no one in queue for comments.
Okay, all right, thank you.
Well, we're done.
I believe we have sub-item G. Would you like me to announce that? The final sub-item is G, board wrap-up and schedule for next steps. The speakers for the sub-item are the Honorable Antonio Vasquez, members, California State Board of Equalization District 3, Honorable Malia M. Cohen, Chair, California State Board of Equalization District 2, Brenda Fleming, Executive Director, California State Board of Equalization.
All right, thank you. Well, thank you to all the work group participants. I appreciate the comments and the feedback. As you know, the board earlier approved the LTA as presented by the executive director, reflecting consensus items agreed to at the November board meeting. And then based on this discussion, it appears that there are some additional consensus items that we need to continue to work on. So colleagues, I'd like to ask for a motion to direct the executive director to begin to dive into additional consensus items that were items to the earlier approved LTA.
Vice Chair Schaefer, I would so move.
Okay. Thank you.
Second.
I'm sorry. I believe that there is no motion needed for this next.
I withdraw the motion. I thought you were asking for one.
I appreciate that. I was asking.
Not a second.
Are there any wrap-up comments?
Yes, Madam Chair.
Please do. Yeah.
Yeah. Chair Cohen, members, I just want to extend my utmost thanks to each and every BOE staff and all the work group participants who made such a tremendous effort to provide expert testimony and cleared your calendar for every hearing and worked on the surveys, letters, and documents, and educated us and brought us to the place where we're at today. With almost a finished LTA to guide and set forth the key principles relevant to providing full and fair remote hearings. Your time and commitment was exemplary, and your constituents should know how well represented they are by your professionalism and your knowledge. And just a big thank you to everybody, especially our staff and your staff and mine, who went out above and beyond to try to get this to where we're at today, and looking forward to bring back some of those non-consensus items next month and see if we can't come up with some resolution.
Appreciate that. Thank you for the wrap-up comments. Ms. Fleming, do you have any wrap-up comments that you'd like to share?
I would echo what has just been shared and extending my thanks and appreciation for everyone who's participated. This has been a significant investment of time and just, amazing intellectual discussions and contributions. So thank you all for taking the time to do so. As you know, members and guests, the board is charged with prescribing rules and regulations to govern the local boards of equalization when equalizing. And so the board, under Ms. Cohen and the board's leadership, will continue to provide the necessary guidance to the counties through this LTA and additions to the assessment appeals manual regarding these remote hearing issues, training, etc. So we'll continue with the work. We'll take the assignment, members, that you've offered, directed us today, and do our best to come back to you with a quality product that can be then revisited, and as a part of the actual board adoption at the next meeting. We look forward to the additional upcoming items that are still outstanding that we'll continue to discuss at the February meeting also. And just continue to look forward to working with all of you to try to get something that works for everybody, for both sides. So we're working as partners to do the best on behalf of the taxpayers and the citizens who are impacted by this process. So thank you for the time.
Mr. Vice Chair Schaefer.
Thank you, Madam Chair. I'm glad that our key stakeholders have all been able to come to consensus on the majority of the policy issues regarding the Assessment Appeals Board that we have in California. I want to thank the stakeholders for your cooperation and willingness to give and take and reach this consensus. Especially want to thank my colleague, Chair Cohen, and former Chair and Member Vasquez for your outstanding staff's assistance in lending this important and challenging process to create reform that works for all of our taxpayers and our professional individuals. Thank you, Brenda Fleming, David Young, Richard Moon, and your staff for your long hours of working with us. It's my hope that a few remaining items can be negotiated to a positive conclusion. I was especially impressed with Richard Parker's assuring us the fundamental fairness of the Assessment Appeals Board, that they're not really in favor of the assessors or in favor of the taxpayers. They're in favor of fundamental fairness for everybody. And in closing, I'd like to remind everybody that today is the 64th birthday for Ellen DeGeneres. I have a soft spot in my heart for our comedy people in America, and we've lost 3 of them in the last 60, 90 days, and I'm so glad to see the comedy is still with us and all the tragedy we've had, including 3 journalists in Tijuana that we've lost this year. Thank you.
All right, thank you very much. I just want to thank the work group participants and the co-chair and the entire team. I particularly want to uplift my staff that have been tremendous, who put a tremendous amount of work into producing today's board meeting and specifically this hearing. Yesterday, today, we've did a lot of work, and we've had a productive 2 days. We will adjourn at this time. Our next meeting is scheduled for February 23rd and 24th of 2022. Is there anyone have any other comments they'd like to say? Ms. Stowers?
Thank you. I would like to adjourn in memory, but I want to defer to Member Gaines first. Adjourn in memory of the fallen Elk Grove police officer. Member Gaines, it's your district.
Thank you.
Yes, thank you so much for bringing that up, Member Stowers, and very sad situation where an officer lost his life on the freeway as a result of someone driving the wrong way. And you know, there's been a couple of tragic incidents in Sacramento County. We had the officer in Galt that was rushing to the Caldor fire a couple of months ago, and it was an individual in a truck, I think under the influence. I'm not clear on that, but that individual went over the K-rail and caused the death of that particular officer. Now this is a second officer who's lost his life. So our thoughts and prayers go out to the family and for the heroism that we continue to see in public safety and the efforts that they're making to keep the citizenry safe. So thank you, Member Stowers.
Thank you. Next speaker is Antonio Vasquez.
Along those lines, we also lost one of our officers down here in LA, Arroyo, a young officer in a shooting. And then also there was a firefighter, I think down below. Firefighter might have actually been in Mike Schaefer's district, but just he may mention that as well. So I'd like to adjourn in those 2 at least, and the others that were mentioned as well. And in closing, on a more up note, is just, you know, I know we're going to get a California team in the Super Bowl. Hopefully it's the Rams. Go Rams, but no offense to
Go
my chair.
49ers.
Thank you. All right, let's keep it civil.
If I could,
Mr. Gaines.
Mr. Cohen, if I could just expand on it to give full respect here. It's Officer Linehan, and yes. So I just want to make sure that we're recognizing him fully. And I apologize for not mentioning his name earlier. Thank you.
No problem, understood. Okay, I think that brings us to a closure. It's 1:05, ladies and gentlemen, and this meeting is adjourned. Thank you.